Hello and welcome to today's episode of You and the Law. I am your regular host, Gentle Queen. On this episode, we will look at the offense of stealing. This offense can be found through sections 382 to 390 of the Criminal Code. The offense of stealing was known under English law as larceny. The major difference between crime of larceny and stealing is that while larceny is the theft of personal goods from the possession of another, stealing, on the other hand, occurs when a person fraudulently takes, or fraudulently converts, to his own use, or to the use of another, anything capable of being stolen. The offense of larceny connotes the taking of the goods from the possession of another person, without that person's consent. This is unlike stealing, where the stolen thing need not be in the possession of the owner. Section 383, 1-6 of the Criminal Code defines stealing in the following words. 1. A person who fraudulently takes anything capable of being stolen, or fraudulently converts to his own use, or to the use of any other person, anything capable of being stolen, is said to steal that thing. 2. A person who takes, or converts anything capable of being stolen, is deemed to do so fraudulently, if he does so with any of the following intents. An intent permanently to deprive the owner of the thing of it. B. An intent permanently to deprive any person, who has any special property in the thing, of such property. C. An intent to use the thing as a pledge or security. D. An intent to part with it, on a condition as to its return, which the person taking or converting it may be unable to perform. E. An intent to deal with it in such a manner that it cannot be returned in the condition in which it was, at the time of the taking, or conversion. F. In the case of money, an intent to use it, at the will of the person who takes or converts it, although he may intend afterwards to repay the amount to the owner. 3. The taking or conversion may be fraudulent, although it is effected without secrecy, or attempt at concealment. 4. In the case of conversion, it is immaterial whether the thing converted is taken for the purpose of conversion, or whether it is at the time of the conversion, in the possession of the person who converts it. It is also immaterial that the person who converts the property is the holder of a power of attorney for the disposition of it, or is otherwise authorized to dispose of the property. 5. When a thing converted has been lost by the owner and found by the person who converts it. The conversion is not deemed to be fraudulent if at the time of the conversion, the person taking or converting the thing does not know who is the owner, and believes on reasonable grounds that the owner cannot be discovered. 6. A person shall not be deemed to take a thing, unless he moved the thing, or causes it to move. This is the provision of Section 383 of the Criminal Code. It is important you study it for better understanding. Meanwhile, I would like to briefly explain some of its implications. To amount to stealing, the thing must have been fraudulently taken, or fraudulently converted. In R. v. Adwasi, 1963, 1 All NLR 316, the chairman of a local government received money on behalf of his council, then he used it as a personal fund. The court held that it was stealing. In State v. Odemayo, 1966, and MLR 92, the accused person obtained £2,500 from the Western Nigerian Housing Corporation for the purpose of erecting a building on a land mortgaged to the corporation. Instead of erecting a building, he used the money to contest an election. The court convicted him for stealing. Why do you think the court arrived at the conclusion that his actions were fraudulent?
I think the court arrived at the conclusion because the corporation would not have parted with the money if the accused had said the money was for election.
That is correct. He converted money meant for something else for his own personal aggrandizement.
Cases of this nature abound in Nigeria today. Why are they not being prosecuted?
Some are being prosecuted. Many others escape prosecution because the government has lost the will to prosecute them.
That is not good for the country at all. People in public office will continue to steal if they know that there are no consequences. However, when examples are made of some people, accountability begins to set in.
I agree with you. Hopefully, those in authority will hear your voice and begin to do the right thing. It is also important to note that before a thing can be said to have been stolen, the thing must have moved. This means that only movable things can be stolen. Also, to amount to stealing, the thing stolen must be a thing capable of being stolen. Similarly, under English law, the thing stolen must be a property. Property under English law is defined as including money and other property, real and intangible things. To amount to stealing, the thing stolen must have an owner. Here, owner is used in a limited sense. Of course, we understand that there can be ownership without possession. Possession is the physical control of the thing owned. Therefore, it can be said that an owner can steal his own property, where his property is in the possession of another person that has a lien over it. To amount to stealing, the thing stolen must have a value. Also, there must be evidence that the accused intended to deprive the owner permanently of the thing taken or converted. This can be inferred from the action of the accused. A finder of lost property will be guilty of stealing if at the time of his taking or converting the property, he knew the owner, or the owner could reasonably be found. If a person comes into the possession of the property of another by mistake, and he fails to return the property after realizing his mistake, it is stealing. To amount to stealing, the taking and conversion must be without the consent of the owner. Consent being preferred here must be genuine, and not induced by trick, force or intimidation. If the property is taken without the owner's consent, it would still amount to stealing, notwithstanding the fact that it was taken openly and without secrecy. Another important ingredient of the offense of stealing is the existence of the thing stolen. Before a court of law can convict an accused person for stealing, the prosecution must prove the existence of the thing allegedly stolen.
So, before a charge of stealing can stand, there must be proof of fraudulent taking, or fraudulent conversion?
That is correct. And in either case, there must be present one of the intents mentioned in Section 383(2) of the Criminal Code. In the absence of any other question, let us now discuss our case study. This will also help us appreciate how the Supreme Court interpreted and treated the offense of stealing. On the 30th day of October, 1992, one Aminu Musa Benji was found guilty of the offense of stealing. The facts of the case, and reasons for the judgment, are as set below. Call the case.
Aminu Musa Benji versus the State, Pillar, 24,751, SC. The accused person is in court, my lord.
Any legal representation?
With profound respect to my lord, I am Bassie West. My appearance is for the prosecution. Respectfully, sir, I am Jude Johnson. I am representing the accused person.
Read the charge to the accused person.
That you, Aminu Musa Benji, between July 1986 and November 1987, at Malit Ibadan, stole a total of 1,273,593 naira, 75 kobo, belonging to the Associated Commodities and Foodstuff Nigeria Limited. An offense of stealing, contrary to and punishable under Section 399 of the Criminal Code Laws of Oyo State. Guilty or not guilty?
Not guilty, my lord.
Call your first witness, prosecution counsel.
As the court pleases. Please tell the court your name and what you do for a living.
My name is Mr. Benga Michael. I am the Managing Director of Associated Commodities and Foodstuff Nigeria Limited.
Please tell the court why you are here today.
Thank you, sir. On the 24th day of March, 1986, our company was trying to import some goods. We tried to get foreign exchange, but we could not. So my company approached Wominco Nigeria Limited to assist with the importation. The accused person is the Managing Director of Wominco Nigeria Limited. When we made the offer to him, he accepted to help us import tire, tubes and granulated sugar. We paid him a total of 1,180,593 naira, 70 kobo, in 2 installments. Despite these payments, an agreement reached with him, the company and himself failed to supply the goods paid for, nor refunded the various sums of money collected. After repeated demands which were ignored by him, we reported to the police.
When you made the payments to him, did he issue you any receipts?
He only issued receipt in respect of the second installment after much pressure.
The copy of the receipt was admitted in evidence and marked Exhibit B.
That will be all for the witness, my lord.
Any cross-examination?
As the court pleases. Mr. Benga, Wamiko is a limited liability company. From your testimony here in court, your company transacted with Wamiko Nigeria Limited, and not with Mystery Banji as a person. So I ask, did you transact with Wamiko Nigeria Limited, or with Mystery Banji?
We transacted with Wamiko Nigeria Limited. However, throughout our transactions and negotiations with the company, the accused person was the only person we saw. He seemed to be the all-in-all of the company.
That will be all for the witness, my lord.
Prosecution called other witnesses, who corroborated the evidence of the director, buttressing the fact that despite the payments made to the accused person, he did not supply the goods, nor refund the money. The accused person in his evidence did not deny receiving the money. He only stated that the transaction was between the two companies, and not him in person. After the address of counsel, the trial court delivered its judgment. I find that the monies paid to the accused for specific purpose had not been utilized for that purpose. The accused collected the money fraudulently. I find the accused guilty of stealing and sentence him to 5 years imprisonment with hard labor, or a fine of 5,000 naira. Dissatisfied with the judgment of the court, the accused appealed to the Court of Appeal. His appeal was dismissed. He appealed further to the Supreme Court. One of the issues before the Supreme Court was whether the prosecution proved that the sum of money stolen from Associated Commodities and Foodstuffs Nigeria Limited were traced to the appellant. On Friday, the 5th day of June, 2015, the Supreme Court delivered its judgment.
The definition of stealing is given in Section 383 of the Criminal Code Laws of Oyo State. It is not disputed that the various sums of money were paid to the appellant for the purpose of purchasing tires, tubes and granulated sugar. This can be seen from the evidence of numerous witnesses called by the prosecution and numerous exhibits tendered at the trial. To sustain a charge of stealing against an accused person, the prosecution must prove that the thing stolen is capable of being stolen, that the accused has the intention of permanently depriving the owner of the thing stolen, that the accused was dishonest, and that the accused had unlawfully appropriated the thing stolen to his own use. The question, however, is whether there is basis for imputing fraudulent intent on the appellant to cover the money to his own use. A man's intention is subjective in nature and can neither be read on pages of paper nor on the face. It can only be deduced from the actions which, when it is exhibited, will often speak louder than voice. The conclusion as to whether or not the appellant acted in good faith is best deduced and explained from the evidence produced at the trial court. There is no hide and seek in the behavior exhibited by the appellant in his intention to permanently deprive the Associated Commodities and Foodstuff Limited of their money. Another question is, did the appellant keep the terms of agreement to supply the goods? It is on record that monies were paid to the appellant for the purchase of the items, which he failed to supply. The appellant did not adduce evidence that he did use the money for the purpose it was meant for. He did not also return the money, either on his own volition or even on demand, despite the pressure mounted on him by the company. The conduct of the accused is reprehensible. In this case, fraud is the issue. Money was paid to the appellant for a specific purpose. He failed to use it for that purpose and did not refund it. He acted fraudulently. The offense of stealing is proved against the appellant who dishonestly, unlawfully appropriated the money paid to him. It is not out of place to conclude in the circumstance that the case falls rightly within the provision of stealing by conversion under the Criminal Code. The offense of stealing occurs when a person fraudulently converts to his own use or to the use of any other person anything capable of being stolen. If money given for a specific purpose is neither used for that purpose nor returned on demand, or at a reasonable time thereafter, the case comes within the provision of stealing by conversion under the Criminal Code. The appellant, having failed to supply the goods he undertook to supply to the Associated Commodities and Foodstuffs Limited, and having failed to return the money paid for the goods, is deemed to have the intention of permanently depriving the company of their money. By so doing, he has committed the offense of stealing the sum of money paid to him by the Associated Commodities and Foodstuffs Limited. In sum, this appeal lacks merit. It is dismissed. The judgment of the court below is affirmed. In consequence, the conviction and sentence of the appellant is hereby affirmed.
Welcome back. I believe this case explains the offense of stealing very effectively. Thank you for being part of today's episode. Please subscribe to my channel. Bye. See you soon.